I'm not sure. Yeah, I don't know.
There is a smart version of them arms, otherwise I active for your argument.
I want to have a butter biscuit. Give it to Dolly.
Yes.
Take mine.
Okay, thanks. Next.
Tell Rebers and Bones they need to up their game. Snacks.
I think it's more cigarette.
Norton's is the gold standard.
Yeah, exactly.
It's actually Nina that's the gold standard. Nina and Mandla. Mandla came in this morning acting as the advocate with a robe. Mac stashed with good. Have you seen this? The judiciary. I don't want to do anything. I'm using Dolly's words.
Yeah.
I just follow my client's instructions.
It's just no missing out. Whoever pays. Okay, yeah. Yeah, this week. And I hope it's over. Sure. Even for me, that's all.
I'm sure you were going to say there's nothing to reply to.
Yeah.
I mean, what is
No, so far.
So far.
Let's see how next week.
Yeah, next week is
I'm our only hope.
Yeah. The last hope.
He's our only hope.
The last hope. No, but now we just go home.
We've made all the submissions you needed to hear today.
Yeah, yeah. In support of my case.
Supported your case.
Yeah, you're everything. Day and night. It should be a night video.
Yep, I'm back like I never left.
By the time your thing came to about 7.
Yeah.
That's when I was actually, there might be a chance to keep it midnight.
But they must be early and you see some.
Yes, exactly. Like limited 4 a.m. Yeah. In fact, what we do is
I could, it's like their fault.
Yeah. How about the new Yeah. No, it was like this with those elections. Urgent after urgent after urgent.
All right, then, Todd.
Yes, Mr. du Plessis.
Thank you, my lord. My lord, I'm going to be dealing with 3 topics, and in some respects I can be obviously much shorter than my predecessors. The first topic is to explain to my lord why there are no rights that have been shown by the applicants to justify their relief. No rights that, in other words, justify their declaratory stroke review relief,
Yeah.
nor rights that justify their alternative interdictory relief. I'm then going to turn, my lord, to look at constitutional harm, which Freedom Under Law submits has been somewhat glossed over to this point. There are very important features of this case which my lord would take account of in any exercise of judicial discretion.
Yeah.
And related to that, and then the third point, my lord, is finally the question of costs. And I'm going to be dealing with that in the context of scandalizing statements which have been contained in a media report by the MK party. My lord, let me start then immediately with the issue of rights. We have listened to the debate, and it really now seems to be common cause through my lord's questions that the issue is the right to a rational decision, whether that is something the JSC rationally exercised when it decided to refuse the postponement. Lord, we say that the JSC was, Mr. Menetje says, correct. We say it was not just rational, it was perfectly rational in doing so. And my lord, we say that because it had been confronted with a question about Section 178 and composition. That is set out in the letter by MK's attorneys that was written to the JSC in justification for the postponement. And I'll take you there in a second, my lord. And the response to that was the reasons letter that we've already looked at by the JSC. Again, I'll have to quickly take you back to that. But my lord, let me just immediately say that in any event, my lord's point right up front is that all of this is an irrelevancy. This debate around composition is an irrelevancy in light of the fact that it misses the point. Because as my lord put it, I think it was to Mr. Mpofu, the JSC is bound by the brute fact of there being an order of a court. That order of the court, it said that Mr. or Dr. Schlopper is not permitted to attend the JSC's meetings next week. But, my lord, let me take you down into the debates, because we've had the benefit of those debates a couple of weeks ago in the Western Cape High Court. I can therefore give you, my lord, an explanation for why what is in the Western Cape High Court's judgment is directly related to this very debate of Section 178. So, my lord, let me take you, if I may, to the JSC's letter. And that letter is MM5. My lord, we looked at it earlier.
Yeah.
And my lord, you'll see that the JSC says that it had an urgent meeting, and it was noted, these are its reasons as we've been describing them. The judgment of the full court did not set aside the decision of the National Assembly to designate Dr. Schlopper as a member of the JSC, and does not therefore impact the composition of the JSC. My lord knows that. Whether it's the question of attendance or quorum or composition, that's how they understood the point. One can have a quibble about whether it's the right terminology in law. It doesn't matter. The point is they understood that was the issue. And then they said the JSC thus remains lawfully composed in terms of, and importantly, my lord, Section 178 of the Constitution, and there's no violation of Section 171H. They go on to say at the top of the next page, while the full court has interdicted Dr. Schlopper on an interim basis from participating, it expressly found that his absence would not render the JSC's decisions or processes unlawful. So, my lord, they knew that the issue of composition and the interpretation of Section 178 of the Constitution was the issue that they were responding to. And, my lord, it's not the case, with great respect, that their letter, that letter was what excluded Dr. Schlopper. It was the court order. That's why they were talking about the court order. The proximate cause is wrapped up with the court order. You can't separate the letter from the court order. And, my lord, the JSC looked, therefore, at the interpretation and the composition point. We know that from their letter and their reasons. And Mr. Mpofu, my learned friend, repeatedly said that this case is about interpretation, and that includes of Section 178. And my lord, the predicate for his relief, for our learned friend's relief, is that Section 178, properly interpreted, means what? That the JSC is not properly constituted without Dr. Hlophe being present. That is the predicate for their entire case today. And my lord, our learned friend, Mr. Mpofu, said to us that we didn't understand his case, and that the respondents were unfortunately misinterpreting his case. But with respect, we haven't, because if you look at the founding affidavit, paragraphs 82 to 83, I'm afraid to say, my lord, in my hurried printing off, I didn't get the case lines version.
It's all right. Founding affidavit, paragraphs 82 to 83.
Yes, my lord. So here you've seen, just before that, just so that you can go back, you'll see they are saying various things about what their rights are. And here, my lord, you'll see at the top of the page, paragraph 79, they talk about section 34, then they talk about section 36, and then section 19. But here, my lord, is the heart of their case. They say, most crucial, and in addition, the conduct is inconsistent with the clear provisions of section 178(1)H. More particularly in that, the forced absence of Dr. Hlophe will inevitably result in a major disturbance of the delicate balance intended to be achieved by prescribing that split between members of the ruling party and the bloc on the one hand and members of the opposition parties on the other, and the composition of the JSC as described by the constitutional drafters will therefore, or thereby, have been defeated, which is inconsistent with the relevant provisions of the Constitution. So, my lord, that is their case. They say, most crucially, that's their case. And we've understood their case as that. The JSC understood the letter and the complaint as that. The JSC responded to it by saying, we've thought about it, and even read. And we've decided that the meetings must go ahead, even though you ask for Dr. Hlophe to be there. So, my lord, the problem is that for our learned friends, is that the interpretive predicate of their argument today about Section 178 is the same interpretive predicate that was advanced with trenchantly, I may say, and at length in the full court a couple of weeks ago. It was exactly those arguments. We were in those courts. Mr. Menetche wasn't. He wasn't because the JSC had abided. But I can tell you, my lord, Mr. Bishop and I were there, and those were the debates, the very debates that are now the same debates that are being relied on to animate for the relief sought today. So, my lord, in that context, let me then say that there are two judgments that have been referred to by all of us, which put the debate to rest as to whether it would have been rational for the JSC to consider that interpretational debate of 178 and come to the conclusion that we can't allow him to be there. It doesn't matter if he's not there, it's still composed, and it can still proceed in his absence lawfully. And my lord, those judgments, the Lord knows, it's the JSC decision, rather the Hlophe decision versus the JSC by His Lordship Mr. Justice Sutherland, Victor and Ledwaba. And Mr. Menetche read to you, my lord, from paragraph 39. And then you heard from Mr. Mpofu saying that the SCA Cape Bar Council is binding. And we also heard him saying that it has been binding because of its interpretation of the various provisions. But, my lord, the interpretation has been done, and it has been interpreted by the full court, which with great respect is binding on my lord, in relation to these very provisions. And I want to just please, with my lord's leave, read to you paragraph 52 of His Lordship Mr. Justice Sutherland's judgment. I can't remember if it was, with no disrespect to either Justice Sutherland or Justice Ledwaba, whether it was Justice Ledwaba's judgment, concurred in by them. At paragraph 52, and we've heard our learned friend...
Judgment of the court.
Yes, a judgment of the court.
Paragraph 52.
Paragraph 52.
Yeah.
The court has looked at all of these debates, the ski road cases and new clicks, and it's looked at composition and attendance and quorum. But what is the principle of the case? The court comes to express a principle, which is the principle at the heart of this case. It's what Mr. Mpofu, our learned friend, says is about interpretation. He kept telling us this case is about interpretation. Well, let's see what the court said. It said at 52. And that goes to our next point, the need to avoid paralysis of the JSE. We are enjoined by the rules of interpretation not to interpret Section 178 in such a way that results in the paralysis of the JSE if a reasonable alternative construction is possible. Paragraph 53 goes on. So that is the interpretation that was advanced and accepted by that court, in contrast to the arguments that have been made on behalf of Mr. Schlopper, or Judge Schlopper as he then was. And that interpretational argument was ultimately resolved against Dr. Schlopper as he now is. And it was resolved in those terms by the court. So the full court, my lord, has ruled that one has to avoid paralysis by the JSE, and that you have to avoid paralysis by an interpretation that avoids the impossible. And Dr. Schlopper's arguments today, with great respect, my lord, seek to paralyze the JSE. Not, as Mr. Bishop pointed out, not to seek an order that he can return to the JSE, but that the JSE en bloc cannot sit. And my lord, that is paralysis exemplified. And in that context, my lord, you've got to ask this question. The JSE knew that the request that was being made of them in the letter by Dr. Schlopper and the MK's attorneys was to effectively have paralyzed the next week, and who knows for how long. And they looked at the interpretational points. They say so in the letter, 178, and they said, we're going for a different approach. And then the only question from the Lord is it a rational one? And we would say with great respect, of course it has to be rational. They've got in their favor the judgments which I've just highlighted for my Lord. They know that these very arguments were debated in the court at a full length. And they know that the court ultimately came to the conclusion, as it did in paragraph, I think it was 56 that everybody's read from the Western Cape judgment more recently, where in the end the court said at paragraph 56, I think Mr. Manechi quoted it, the absence of Dr. Schlopper on the JSE would not be significant. There would still be 5 NA members represented on the JSE, constituting a majority of such members. That's the point. So, my lord, the first point we can summarize is the following. There would be, through the interpretational arguments that our learned friends for the applicants propose, my lord agreeing with them and paralyzing the JSE against the binding authority that I've highlighted for my lord. But my lord doesn't need to be concerned about that, because the only question before you is the rationality of the JSE's decision in any way justified? And for all these reasons, of course, it has to be justified. It would have been thoroughly irrational for the JSE to have done the opposite. My lord, just posit this. The JSE says, thank you, we take your letter. We know we've spent all this money. We know all these people are coming. We know that there is a huge demand for judges to be obviously appointed to ensure the backlogs in the courts are fixed. We know all of that, but we're going to nevertheless adjourn. That would have been thoroughly irrational. So, my lord, with great respect, there are no good reasons that have been advanced by our learned friends. There is a second point related to this, and it's the question of jurisdiction. We say this with respect to my lord, but until Dr. Schlopper obtains a court order overturning the interim interdict that has been granted by the Western Cape High Court, until he obtains that order overturning it, or he wins on appeal, or he wins in Part B, he is interdicted. Full stop. My lord's point is the brute force of that order. And he cannot seek from my lord to undo that order, because it's binding on him and it's binding on my lord. As an order, orders of courts bind everybody. They bind my lord as well, section 165.4 and section 165.5. So, my lord, if he wishes to undo that, he has a remedy. My lord doesn't need to feel as though you've locked him out of court and that section 34 rights have been violated. His remedy lies in section 18. He can go to the Western Cape High Court, the court that granted the interdict against him, effectively, and say and immediately allow for that order to be suspended, if that's what he wants to do. There's been a debate about 18.2, 18.3, my lord. I don't want to take you back to that, other than to highlight the following, because again, our learned friend Mr. Mpofu said that we've misunderstood his case, and that clearly they don't need a section 18.3 remedy, because just by having applied for leave, it suspended the operation of the order. But my lord, that's not the position from their own letter. And some of it was read to you, but I need to take my lord to it. It's MM3, it's the letter by the attorneys.
Yes, I have
For
it.
you have it, my lord.
Yep.
And if, my lord, if you go to 02-121, paragraph 5. Now, these are the attorneys that are writing to the JSC, trying to explain to the JSC why the JSC must postpone next week's meetings. And look at what's said at 5. There again, at 5, they raise the 178(1)H argument, my lord. No debate. They are wanting to retread those arguments. Second, my lord, it says, the undesirable situation is exactly what will obtain unless before 7 October 2024, Part B of the High Court application or the Africa Forum application pending before the Con Court is heard and decided. That's gone away, by the way, my lord. The Constitutional Court has said no. Or the National Assembly designates another person, assuming that it's constitutionally possible to do so, which they deny. And then the outcome, my lord, of any application for leave to appeal and or proceedings in terms of Section 18 of the Superior Courts Act. My lord, on their own letter, they explained that they knew Section 18 was where they would be able to avoid what they said was that outcome. So, my lord, that's the Section 18 point. We've understood perhaps Mr. Mpofu's argument incorrectly, but that is what his client's letter said through the attorney. So, my lord, let me then next say on jurisdiction that there is an insuperable further difficulty for our learned friends, and that's the judgment of His Lordship Mr. Justice Olson in my division, my lord, in Durban, Aqua Transport. My lord, in that case, there had been a review, and excuse me, there'd been a review, it had been successful. There'd been a decision to apply for leave to appeal against that review's decision. There was then a separate case which was brought for an interim interdict. So the review had been before His Lordship Mr. Justice Lopes. There was a separate case brought for an application for an interdict, but like before my lord, for an interim interdict pending the outcome of that appeal. That is effectively what His Lordship was dealing with in that case. And His Lordship Mr. Justice Olson refused it on the basis of the analysis that I don't know if you've had time to have a look at, my lord, but it's in our heads of argument. I'd ask you to take a bit of time there. It's at paragraph 25 of the heads of argument that Freedom Under Law filed.
Yes, thank you on that.
So, my lord, if I can just take you to the paragraph before that, because that it's situated. Olson J. refused to do so on the basis that, given the extant judgment against the applicant had failed to prove any right to the interdict. He explained, I find it difficult to conceive of a circumstance which throws more serious doubt upon a claim that prima facie proof of the existence of a right has been established than the fact that the court has already adjudicated, in that case finally, upon the matter, determined that the right doesn't exist. But then, critically, next paragraph. Having made those observations, I still find myself in difficulty with the proposition that this court, sitting otherwise than as an appeal court, has the power or discretion in effect to overrule, or at least to second guess, a prior decision of this court in order to grant a temporary interdict pending appeal. And he said he wants to turn his face against that. Why? Because the practice or procedure which involves, like my lord, another judge, deciding the quality of prospects on appeal before the judge who heard the main case has decided whether the threshold of reasonable prospects of success on appeal is met, undermines Section 17 of the Superior Courts Act. He says that section carefully reflects the balance. And then you'll see the bolded point next. In my view, unless the application for the interdict is brought before the judge who made the decision subject to appeal, a glaring error on the part of the original judge must be apparent in most cases before interim relief is granted. Otherwise, there'd be nothing short of a whole re-hearing that would be required. My lord, as we say...
Nothing in this case requires me to go into the full court's decision-making or criticise it or approve it in any way.
No,
And the question is, what is the effect of the order?
Yes, but in order to get to whether the order has that effect,
Yeah.
there is the debate about rationality.
Yes.
And that debate engages
Well,
the very debates.
the question of rationality is, did the JSC properly apprehend the effect of the order?
Yes, but in order for that to be answered, then we get back to the debates about whether it was properly understanding the interpretation of Section 178 and the debates that we've been having about those
I'm not
judgments.
sure that's right. I mean, the fact of the interpretation is different from its correctness.
Yes, but
So if one, the question is, there's the decision of the full court, its order. Its order has to be interpreted in light of its reasons.
Yes.
Those reasons are presumed to be correct
Yes.
in order to interpret the order.
Well, my lord, you've put it perfectly. Except you are being asked by the applicants to presume that it is not correct because of their arguments, which are the very arguments that were raised by them there but rejected by that court. That's the conundrum. So, my lord, the moment that position is clear, that my lord accepts the reasons as being correct and that those reasons justify the order, then there's no room, and this is the point. It's the same point with great respect that Justice Olsen was, I think, putting. There's no room for another court to have to go through that process.
As I understand the applicant's case, their case is there are two ways the JSC can comply with the order, a rational one and an irrational one. They say the rational one is to postpone all proceedings
Yeah.
until the interim order is confirmed or discharged.
Yeah.
JSC differs, and that's the terrain on which we're having the argument, I think.
I think that's correct.
Yeah.
And for the reasons that I've given, my lord, if that is the approach,
Yeah.
then these are the other difficulties, if I may say. My lord
Yeah.
doesn't need to get into these difficulties,
Yeah.
but they arise unless one focuses on exactly what my lord has said.
Yeah.
That's with
I mean,
respect, that's...
given the time
Yes.
that I have to decide this case, I think the shortest distance between 2 points is a straight line, isn't it?
Wilson's razor, my lord.
Sorry?
Wilson's razor.
Yeah. Well, I mean, call it what you want, but it just seems to me that I have what's been placed before me is a very narrow question of whether or not the JSC rationally exercised
Yes.
its power to refuse to postpone next week's and I think the week thereafter's interviews, and that narrows down the focus or the squint with which I must regard the full court's decision.
Yes.
The decision is not a disquisition with which I have to have a Socratic dialogue. It's just a fact. It's just there,
Yes.
and I must and I must put myself in the position of the JSC when it had regard to the fact of that decision.
Absolutely. And, my lord, the question of whether the JSC's rationality arises from its understanding of what the court had decided
Yes.
in light of the debate around what's engaged.
Yes.
My lord,
Yes.
we're on the same page.
I mean, of course, if the case was that it completely misconstrued what the judgment and the order meant,
Sure.
but that's different from disagreeing with it, or criticizing it, or affirming it.
Yes. But a component of the rationality, and this will be my last submission on this, is whether it was appreciating what the alternative arguments were, and they are there in the letter. They knew it had been debated, and it was then asking itself, well, what is the alternative?
Yeah.
And that is the debate that it ultimately decided on a rational basis was in favor of
Yeah.
effectively agreeing with the intent. So,
Yes,
my lord,
thank you. I have that point, yeah.
Yes, my lord. So then, in that context, my lord, we say that the next important issue for my lord to consider, and I needn't be long on this at all, is constitutional harm.
Yeah.
And I don't need to be long on it because my lord has written the Nyazi Rail judgment, and we are aware of that.
Yes.
And we've cited it for my lord in the heads. But my lord, we see the constitutional harm as being particularly important. It goes, we heard the debate with our learned friends, and we agree with you, my lord, it's a debate about where this constitutional harm fits. And it fits in two ways. It fits in, if it's an interim interdict, of course it fits in there at the outer level. But it also fits into the debate, we agree, on what is a just and equitable remedy if
Yeah.
my lord were to have to go there.
Yeah.
So, my lord, we say that there are, we've identified 5 harms. The first harm is a critical one, is that it's the rule of law itself which requires, obviously, that the judges be permitted, or the JSC rather be permitted, to fill the spaces, not just for the sake of filling spaces, but in order to ensure the constitutional end itself of the Bill of Rights being protected by judges who fulsomely are able to do so. The second harm, obviously, is for everybody that's having to come there but now can't, from the Chief Justice to the Judges President and so on. The third harm, my lord, is, of course, the public resources that have been squandered. And the difficulty of trying to have these meetings. It takes months to set them up. We've heard the argument from our learned friends, well, it can done just another 2 or 3 months and can be sorted out. Well, firstly, that's not the relief they're seeking. But in any event, it's simply not appropriate. There's no evidence of it, but the public evidence that we're all aware of is that it takes 3 months. The fourth is the administration of justice. And here, just on the evidence, my lord, there is an insuperable difficulty for our learned friends on constitutional harm. Because Dr. Schlopper doesn't begin to address the irreparable constitutional harm at all. He doesn't do so. Versus the evidence that you've got, we all referenced earlier Mr. Nkatobe's affidavit. But if one looks at that affidavit, he personally says, my lord, that he collated the evidence regarding the impact of the intellect on the functioning of the courts, specifically the Supreme Court of Appeal, the KwaZulu-Natal Provincial Division, the Land Court and the Labour Court, by directly engaging with the heads of those courts. So my lord has that evidence from him through those judges. And my lord, it's not a case of him creating an extra reason. The reasons are given. The JSC is providing you an explanation for why it thinks its reason was absolutely right. And it had already said that it wanted to continue on this basis.
Yeah.
So, my lord, those are submissions on constitutional harm, and they will weigh in the balance heavily, we say, with respect. My lord, and then finally, on costs. And my lord, we are not in the fortunate position of the JSC, who can be magnanimous, because, as you'll have heard from Mr. Bishop, the DA has asked for punitive costs, and Freedom Under Law does so as well, my lord. And they've been scandalized in this case. Your Lordship knows that after the MK party and Dr. Schlopper were unsuccessful before the full court, they didn't seek urgent legal redress. Lord, what they did is they published the media statement. And that media statement, Lord, is for my Lord's benefit. It is
I've read it.
06235.
Yeah.
The statements that are made in there, my Lord, are scandalous, obviously, and they go to the very heart of the idea that the judgment is something sacrosanct and to be respected. And with great respect, we say that as a result, there are numbers of provisions of the Constitution which are immediately implicated. Not least of all because Dr. Schlopper is a member of Parliament, he's the deputy leader of the MK, he's the parliamentary leader, and of course, we know then that those obligations on him are 165 and 173 of this court's powers to protect itself from such conduct. And my lord, the difficulty is that we're not making, it's not just the content, it's not just statements that have been made in that media statement. It's the fact that it's a continuation of the same conduct that has been deprecated by the Constitutional Court. And my lord, in the answering affidavit by Freedom Under Law, but to take you there very briefly, it's at 06204, paras 27 to 28.
06204.
Yeah.
Yeah.
What happened there is, as my lord recalls, the contempt case, and then after the Constitutional Court issued its judgment, statements made by Mr. Zuma. And the Constitutional Court...
In this case requires me to go into the full court's decision making or criticise it or approve it in any way.
No,
and the question is, what is the effect of the order?
Yes, yes, but in order to get to whether the order has that effect,
Yeah.
there is the debate about rationality.
Yes.
And that debate engages the very debates.
The question of rationality is, did the JSC properly apprehend the effect of the order?
Yes, but in order for that to be answered, then we get back to the debates about whether it was properly understanding the interpretation of Section 178 and the debates that we've been having about those
I'm not sure that's right. I mean, the fact of the interpretation is different from its correctness.
Yes, but
So if one, the question is, there's the decision of the full court. Its order has to be interpreted in light of its reasons.
yes,
Those reasons are presumed to be correct
yes.
in order to interpret the order.
Well, my lord, you've put it perfectly, except you are being asked by the applicants to presume that it is not correct because of their arguments, which are the very arguments that were raised by them there but rejected by that court. That's the conundrum. So, my lord, the moment that position is clear, that my lord accepts the reasons as being correct and that those reasons justify the order, then there's no room, and this is the point. It's the same point with great respect that Justice Olsen was, I think, putting. There's no room for another court to have to go through that process.
As I understand the applicant's case, their case is there are two ways the JSC can comply with the order. A rational one and an irrational one. They say the rational one is to postpone all proceedings
Yeah.
Until the interim order is confirmed or discharged.
Yeah.
JSC differs. And that's the terrain on which we're having the argument, I think.
I think that's correct.
Yeah.
And for the reasons that I've given, my lord, if that is the approach,
Yeah.
then these are the other difficulties. If I may say, my lord
Yeah.
doesn't need to get into these difficulties,
Yeah.
but they arise unless one focuses on exactly what my lord has said.
Yeah.
That's with
I mean,
respect. That's
given the time
yes.
that I have to decide this case, I think the shortest distance between 2 points is a straight line, isn't it?
Wilson's
so-
razor, my lord.
Sorry?
Wilson's razor.
Yeah. Well, I mean, you can call it what you want, but it just seems to me that I have what's been placed before me is a very narrow question of whether or not the JSC rationally exercised
Yes.
its power to refuse to postpone next week's and I think the week thereafter's interviews, and that narrows down the focus or the squint with which I must regard the full court's decision.
Yes.
The decision is not a disquisition with which I have to have a Socratic dialogue. It's just a fact. It's just there,
Yes.
and I must and I must put myself in the position of the JSC when it had regard to the fact of that decision.
Absolutely. And, my lord, the question of whether the JSC's rationality arises from its understanding of what the court had decided
Yes.
in light of the debate around what's engaged.
Yes.
My lord,
Yes.
we're on the same page.
I mean, of course, if the case was that it completely misconstrued what the judgment and the order meant,
Sure.
but that's different from disagreeing with it, or criticizing it, or affirming it.
Yes. But a component of the rationality, and this will be my last submission on this, is whether it was appreciating what the alternative arguments were, and they are there in the letter. They knew it had been debated, and it was then asking itself, well, what is the alternative?
Yeah.
And that is the debate that it ultimately decided on a rational basis was in favor of
Yeah.
effectively agreeing with the internet. So
Yes,
my lord
thank
is,
you. I have
is
that
also-
point, yeah.
Yes, my lord. So then, in that context, my lord, we say that the next important issue for my lord to consider, and I needn't be long on this at all, is constitutional harm.
Yeah.
And I don't need to be long on it because my lord has written the Nyazi Rail judgment, and we are aware of that.
Yes.
And we've cited it for my lord in the heads. But my lord, we see the constitutional harm as being particularly important. It goes, we heard the debate with our learned friends, and we agree with you, my lord, it's the debate about where this constitutional harm fits. And it fits in two ways. It fits in, if it's an interim interdict, of course it fits in there at the outer level. But it also fits into the debate, we agree, on what is a just and equitable remedy if
Yeah.
my lord were to have to go there.
Yeah.
So, my lord, we say that there are, we've identified 5 harms. The first harm is a critical one, is that it's the rule of law itself which requires, obviously, that the judges be permitted, or the JSC rather be permitted, to fill the spaces, not just for the sake of filling spaces, but in order to ensure the constitutional end itself of the Bill of Rights being protected by judges who fulsomely are able to do so. The second harm, obviously, is for everybody that's having to come there but now can't, from the Chief Justice to the judges, president, and so
Yeah.
on. The third harm, my lord, is, of course, the public resources that have been squandered. And the difficulty of trying to have these meetings. It takes months to set them up. We've heard the argument from our learned friends, well, it can be done just another 2 or 3 months and it can be sorted out. Well, firstly, that's not the relief they're seeking. But in any event, it's simply not appropriate. There's no evidence of it, but the public evidence that we're all aware of is that it takes very months. The fourth is the administration of justice. And here, just on the evidence, my lord, there is an insuperable difficulty for our learned friends on constitutional harm. Because Dr. Schlocke doesn't begin to address the irreparable constitutional harm at all. He doesn't do so. Versus the evidence that you've got, we all referenced earlier Mr. Nkatobe's affidavit. But if one looks at that affidavit, he personally says, my lord, that he collated the evidence regarding the impact of the interdict on the functioning of the courts, specifically the Supreme Court of Appeal, the KwaZulu-Natal Provincial Division, the Land Court and the Labour Court, by directly engaging with the heads of those courts. So my lord has that evidence from him through those judges. And my lord, it's not a case of him creating an extra reason. The reasons are given. The JSC is providing you an explanation for why it thinks its reason was absolutely right. and it had already said that it wanted to continue on this basis.
Yeah.
So, my lord, those are submissions on constitutional harm, and they will weigh in the balance heavily, we say, with respect. My lord, and then finally, on costs. And my lord, we are not in the fortunate position of the JSC, who can be magnanimous, because as you'll have heard from Mr. Bishop, the DA has asked for punitive costs, and Freedom Under Law does so as well, my lord. And they have been scandalized in this case, my lord. Your Lordship knows that after the MK party and Dr. Schlorpe were unsuccessful before the full court, they didn't seek urgent legal redress. Lord, what they did is they published the media statement. And that media statement, Lord, is for my Lord's benefit. It is
I've read it.
06235.
Yeah.
The statements that are made in there, my Lord, are scandalous, obviously, and they go to the very heart of the idea that the judgment is something sacrosanct and to be respected. And with great respect, we say that as a result, there are numbers of provisions of the Constitution which are immediately implicated. Not least of all because Dr. Schlorpe is a member of Parliament, he's the deputy leader of the MK, he's the parliamentary leader, and of course, we know then that those obligations on him are 165 and 173 of this court's powers to protect itself from such conduct. And my lord, the difficulty is that we're not making, it's not just the content, it's not just statements that have been made in that media statement. It's the fact that it's a continuation of the same conduct that has been deprecated by the Constitutional Court. And my lord, in the answering affidavit by Freedom Under Law, but to take you there very briefly, it's at 06204, paras 27 to 28.
06204.
Yeah.
Yeah.
What happened there is, as my lord recalls, the contempt case, and then after the Constitutional Court issued its judgment, statements made by Mr. Zuma. And the Constitutional Court said those media statements were put before it. The court recorded that it was admissible evidence, and it said this at paragraph 27. If the publication of these statements had no relation to him, he could have provided an explanation, either publicly or in these proceedings. He didn't. He even had an additional opportunity to dispute his connection to these statements after the hearing of the matter. However, to date, he has made no attempt to distance himself from those statements.
There's a letter asking, I think, Dr. Schlorpe and Mr. Zuma to disassociate themselves from that.
Absolutely.
Press release, is there?
There is, my
Yeah.
lord. So there was a letter written by my clients to their attorneys, the attorneys for the applicants, saying to them, this is a statement that's been put out. It says these things about this judgment. And we would want confirmation as to whether you associate yourself. Now, my lord, what you have, and in light of that passage I've just read to you from the Constitutional Court,
Yeah.
saying, you have the replying affidavit that was filed and that came in, I can't remember if it was at 12 o'clock or 2 o'clock this morning.
I
Paragraph 31 of
already
it.
made clear what I was doing at 2 o'clock in the morning. Yeah.
Paragraph 31 of it, my lord, says
Yeah.
this. So, my lord, there's a further waving away of this. It says the long diatribe. It was a long diatribe. It just happened to be a very long statement. The long diatribe about alleged abusive process is disputed, and it's not worth the paper it's written on. It constitutes diversionary tactics, which have no place in such proceedings. Well, of course they do when they are scandalous of the court and of your opponents. Then it says the letter marked FUL2 was unfortunately missed and will be responded to in due course. But then here, my lord, the final paragraph. Suffice to state the obvious, that neither Mr. Zuma nor Dr. Schlorpe are part of communications. The statements are always attributed to their authors. The witch hunt is therefore misplaced and misdirected. What there is not, my lord, is a paragraph consistent with what the Constitutional Court had said against at least one of the applicants.
Yeah.
Distancing themselves from the statement. Nothing. So, my lord,
Your answering papers seem to suggest that the application should be dismissed toto as an abusive process.
no.
Now you're saying that this is relevant to costs.
It's relevant to
Yeah.
costs as well as to the discretion that my lord can exercise.
Yes. In relation to the declaratory.
Of course.
Yeah.
So it's in relation to declaratory, and it's, well, there are three places it's relevant. It's obviously costs, it's obviously declarator, all declarators are discretionary, and it's also in relation to the interdict, because my lord knows the case law, that an interdict, even considering all the other factors for an interdict, a court can always take into account the questions of abuse of process in deciding whether to grant it. So, my lord, in those circumstances, we do ask for attorney and client costs, and the costs of two counsel. And I'm afraid to say I haven't read the luminous judgment about on the scale C, B, or A, but whatever the right scale is that
Luminous
accommodates
or
it.
voluminous?
Luminous.
Oh. Might be voluminous as well, who knows? Yes, just on costs. You say that the attitude displayed to the full court's decision
Yes.
was scandalous and scandalous in the sense that it constituted a contempt.
Well, scandalous
Well,
against...
scandalising the court is it a form of contempt?
Yes, my lord.
Yeah, I
Yes.
thought it was.
Yes.
And you say that that means a punitive costs order in this case should be made. That's
Yes.
that's the level of the submission, is it?
That is it, my lord.
Mm.
My lord, we're not seeking to hold anybody in contempt or asking my lord to do so. But my lord cannot ignore, you sit in the same judicial branch of government as the judges in that division. You know what the case is about. It's clear before you that this statement has been made by the same parties that are now saying this of the particular judgment. And my lord, it's not that it was a scandalizing statement directed at the judges.
It was pretty clear it was about all judges, wasn't
Absolutely.
it? Yeah.
Blatantly political judgment of this court in respect of the
I just worry about
judiciary as a whole.
I just worry about deciding to attach penal consequences. Sorry,
We're not
penal
asking for quite that, my
just,
lord.
Just forget that word. I worry about attaching punitive, that was the word I was groping for, consequences to an exercise of expression that may or may not constitute contempt of court outside the context of a contempt of court application. This is a highly political case where the applicants are deeply frustrated, I think would be an appropriate word, that the person they chose to sit on the JSC has been temporarily stopped from doing so. And they set this case up as a clash between those democratic rights and the Western Cape, well, the full court's decision to limit them, albeit temporarily, in terms of its decision. So against that background, there's a political ferment. And it's in that context that the press release was made. Now, the press release may well be contemptuous. It's certainly extremely strident. And Dr. Hlophe and Mr. Zuma may well, on the Constitutional Court's decision, be contemptuous and failing to disassociate themselves from it if they ultimately do. Ought that not to be the focus of a much more careful inquiry at the appropriate stage? I've had this case for 48 hours, and I'm being asked by you to say, well, I'm going to make a punitive costs order against Dr. Hlophe and against a party which is the official opposition in the National Assembly, largely because they said some nasty things in a press statement. That may well be turn out to have been unlawful and contemptuous, but there is a difficult underlying question there about the barrier between contempt of court, the exercise of free expression in a political context. Must I determine those issues in this case?
My lord, we would say with great respect, yes. First is it's before you. And you've got the evidence that has been asked of Dr. Hlophe, and then by the letters and the response that I've taken you to. So, my lord, you've got the evidence, one. Two, you've got the Constitutional Court authority in exactly the same situation. And in that case, my lord, I want to double check the authority. I will, while my learned friend is arguing. I recall that was one of the reasons why the Constitutional Court said, not because of contempt of court, but because of that statement, that the court was going to, also as a court of first and final instance, by the way, issue punitive costs.
Yes.
And my lord, the third thing is that it's not only the political nature of the context. Political contestation is always heated nowadays. It's the question of what is said about the courts and about your opponents. About the courts, it's not just the judge in question or the judges, it's the judiciary. But then about your opponents, they are racists, they're masquerading, white malarkey.
Yes, I don't want to be understood in any way as condoning those remarks. I don't. On the face of them, they seem to be well, it would have been better if they weren't made. But the question before me isn't whether those remarks are good or bad. The question is whether particular legal consequences should be attached to them in the context of these proceedings.
Yes.
Yeah, and I think you've made your submissions.
I've made my submission. I'll finish by saying this. My lord has always in every case got to decide the issue of costs.
No, absolutely.
But these are the factors that go into the mix for my lord.
But the ordinary costs decision is much easier normally. It's who won, was a constitutional issue raised, or has anybody misconducted themselves before me? Those are the usual costs inquiries. What you're asking me to do is take into account something at the periphery at best of that, perhaps even beyond that periphery, that involves penalising someone for the exercise of free speech. Potentially. Perhaps it will be appropriate in due course for whoever was responsible for that statement and whoever failed to disassociate themselves from it to be appropriately penalised. I just wonder whether it's something that's appropriate to take into account at this stage.
Well, my lord, we've made our submissions.
Yes, and all I'm doing is opening my mind to you, just in case you want to try and change it a bit more.
I've given you my arguments as trenchantly as I could, and we stand by them.
Yeah.
Thank you. Thank you.
Mr.
Ngolwana, is Mr. Ngolwana going to reply first, or are you?
My lord, no, but if you can just make a request, Mr. Ngolwana may or may not address the court, but Mr. Ngolwana has asked me to make a request for a 5-minute break, and I'm conveying it because I might be the beneficiary of whatever he wants to decide.
Right, okay. Well, Mr. du Plessis was well within time. So literally a 5-minute break, 2:45.
Literally.
Yeah.
Thank you. That's correct.
Thank you.
You're going to blame me for
The most argument you get is on the scale of costs.
I took that as it's sort of like I may grant the clarity.
Just a minute. Do you have a pen? I found one.
Yes. It's at 0-123.
So you're saying this letter is okay? Wait, can I get? Let me get like a key. So this is
The letter to the JSC. It's at section 3 and it's at
just a minute.
page line.
So is it at case line? Anaksha? Letter 2. It's the letter 2, no?
Yeah, the letter of my 02-1.
Dash.
Some POFI have you negotiated?
We have, my lord, and I won.
So are you going to take all of the time, or
Yes.
right?
Well, not all, but I've got it. It's not a target, but at least
Yeah,
I've got
you, Mr. To be precise about this, Mr. Ungolwana has ceded his time
Yes,
to you.
that's correct.
You
May or
don't
may not.
plan on taking all
Absolutely
of it.
not.
Okay,
No, no.
right.
Yeah.
Thank you.
Yeah. Thank you, my lord. My lord, before I do start, if I may just clarify something, shall we call it peripheral defamation? My lord, the Mr. Duplessis was obviously not aware, just as I was not aware of his letter, that we did respond
Right.
to that letter. And I was going to read it into the record, but my lord, it's just been uploaded, if your lordship will accept it. And
Yeah.
it's at 02-62. It's just to say that there was a response. It's whether it's a good
62.
at 02-62, my lord, yes.
0262.
02-.
262.
Oh, yes. 02-.
Oh well, no, it's that I have something labeled correspondence here at 02-60.
60-62. That's correct.
Yes. there
Yes,
we
my
go.
lord, yes. And I'm not going to belabor the point, my lord, simply to say, because to the extent that the accusation is that there was a non-response, which might suggest like nonchalant behavior.
Yes, this is what's referred to in reply, isn't it?
In a way, it's
Or you
a-
say it fell through the cracks. We will respond in due course.
yes.
And this
we
is the response.
take instructions and
This
so
is
on.
effectively a response
Yes.
saying we will respond in
Yes,
due
yes,
course.
yes.
Yeah.
All I'm saying,
Okay.
my lord, is that it's not what it might look like was that, look, you just take it and throw it in the dustbin. That's not what happened.
No.
And Mr. Duplessis, my learned friend, was not aware of that
No.
response. Obviously, he would have brought it to the court's attention.
Thank you.
Thank you, my lord. Okay. Now, my lord, well, I suppose I must first be indebted, before I'm indebted to your lordship, to be indebted to Mr. Ngalwana, because his approach, my lord, is going to allow me just to do a little bit of an extra, hopefully 10 minutes, to situate the case. Because with the greatest respect, my lord, and I'm not saying this flippantly, nothing that I have heard from my learned friends, all of them, suggests that my remark in the morning that we are at cross purposes, and I'm prepared to take some responsibility for that. Maybe we didn't clarify what this case is about. My lord, let me start here. It is the duty of a court, any court in South Africa, shall we say, to prevent and avoid the denial of human rights. Goes without saying, none of my learned friends can quibble with that. And that's the only reason we're here, my lord. Well, we might be right, we might be wrong, that's a different matter. But all we're here for, my lord, and nothing else, is to say, court, my human rights have been violated, and court, because you are the only person who can intervene, save for me going to self-help.
Yes, please don't do that.
No, thank you, my lord, I promise.
Yes.
You are the only person who can intervene, one way or the other, and the court will say yes or no, as
Yeah.
courts always do. Yeah. But really, that's all there is to it. And in crafting that plea to the court to intervene because our human rights are being allegedly violated, we then say, my lord, the manner in which those rights are violated manifest themselves twofold. In the first instance, they manifest themselves by a violation of the rights in the Bill of Rights. And I don't want to go through the list. I said section 1C,
Yes.
9, 10, 34.
Yes.
I'll just stop at that. If we are right about that, then we are entitled to relief in terms of section 38 of the Constitution. And it ends there. And we are also entitled to appropriate relief. That's all. And Section 38 is so lenient that it says if you have a right violated or even threatened to be violated. So even if we all came here, my lord, and we said, look, we're not sure if our right is violated of Section 19, but it's threatened to be violated, the lordship would still give us appropriate relief. So let's close that chapter. That's the Section 38 case.
Yeah.
We then go further. We say, my lord, assume that none of our Bill of Rights have been violated. But there has been an irrationality, which, as your lordship said earlier, is 1C, not chapter 2, chapter 1 now of the Constitution. 1C, and we say there's been other violations, there may be all over the Constitution. And if we're right on that, that's the irrationality decision thing, then your lordship must come to our rescue, but this time in terms of 172(1)(a). Right. And then we say, my lord, if your lordship cannot find, if your lordship says no, neither your Bill of Rights have been violated, nor your other constitutional rights, then we say the court, nevertheless, on the Van Warmelo test, the court is still capable of giving us 172(1)(b) relief. I won't develop it. I did that in the morning. Now, my lord, that's all, and we may be right, we may be wrong. We're prepared to accept that. But our case must not be mischaracterized as something else. And our case is not, I repeat, not to second guess, attack, criticize, backdoor appeal and so on the decision of the Western Cape High Court. But your lordship, in a way, took the words from my mouth. But just as we, my lord, cannot say that that judgment is wrong, just merely because it's on appeal, my learned friends also cannot say it's right. So what we accept is what your lordship correctly beautifully put as the fact of the judgment, that nobody can wish away. It is there, and it must be taken at face value. The other thing that is true about that judgment is what your lordship said to my learned friend, Mr. Du Plessis, which is that in its interpretation, and that's the Firestone cases, Gentoo, Kuro, and so on. All the cases we've listed, SOS, Constitutional Court. In its interpretation, you have to look at the order, and you have to look at the reasons. That's the trite. So your lordship can't just say, I'm looking at this order, it says you must wait until the end of the Constitutional Court, and that's it. The lordship will have to, is bound to on the Endumeni test, to go to the reasons that are given and to interpret the judgment. And quite frankly, my lord, it doesn't matter at all what was argued in Cape Town by either the DA or ourselves or whatever. The test is objective. So the DA might have gone to court to look for 3 cars, but the judgment is about 1 car. All of that is irrelevant. Your lordship is guided by the objective wording of the thing, the context, the usual Endumeni things, and to interpret that judgment. Now, so when Mr. Ngalwana says, look at the judgment, it says MPs, and it says 1 designation, and it says the designation, my word, is indivisible. Then that's it. It doesn't matter that the DA went there only to hunt for Dr. Hlophe or whatever. But if the judgment came out that way, it came out that way. Of course, Mr. Maneche is also correct to say that there may well be some other readings, such as paragraph 56, where they say, oh, well, the other 5 will be there and so on, which go the other way around. That's fine. I'm prepared to do that. But Your Lordship, both on Mr. Manetja's pinpointing of certain paragraphs and Mr. Ngalwana's pinpointing of certain paragraphs, must objectively, yourself, my Lord, say that this is what the impact of the judgment is. So I just wanted to clarify that. Now, and it's not about the correctness of the judgment either. Now, there's another small red herring that was used here. My learned friend, Mr. Du Plessis, I think. Oh, no. Let me stick to this. My learned friend, Mr. Manetja, says correctly, assuming for now he's right on the Section 18 discussion. He says, and it's quite correct, that there were parties in the Western Cape High Court, but not in the Constitutional Court, where they were not cited. But all my learned friends make the same mistake. So they say, well, that judgment is binding on the JSC. Of course it is. It's binding on me as well. But that's not the question before Your Lordship. The question is this, and everyone is eliding this question. The mere fact that there is a binding judgment on the whole world does not mean the JSC is forced to do something. Let me repeat that. The mere fact that there is a judgment of the Western Cape that's the non sequitur. Does not mean that the JSC must decline the postponement request. So it's not bound in that sense. The Western Cape judgment never said the JSC must decline the postponement request. Or put differently, if the JSC granted the postponement request, it would not be breaching the Western Cape judgment.
Yes, you accept the way I put it to Mr. Du Plessis was there were 2 ways to comply.
Absolutely.
One is to continue without Dr. Chlorpe, and
Yes.
one is to not continue
Absolutely.
until Dr. Chlorpe can participate. And the
Yes.
question is whether the JSC's decision to continue without him is
100%.
rational.
100%.
Yeah.
Lord. So, but the way it's being formulated in this court is as if the existence of the Western Cape judgment means that the JSC's hands were tied vis-a-vis the postponement. No. The JSC, while complying with that judgment, could have said, yes, we're going to, nobody would have said, you're in breach, you must go into contempt, go to jail, and so on.
I mean, that's obvious because, as I understand it, minority of the committee of the JSC that made the decision.
Yes.
So
Absolutely.
we should postpone.
100%.
That they should postpone.
Yes. And
No.
absolutely, my Lord.
It
That's
clearly has
correct.
to be approached on the basis of the fact of the judgment and the rationality of
Absolutely.
the JSC's
That's all.
response to it.
That's all. That's all. And Your Lordship, no, I won't belabor the point. Your Lordship has hit it. The mere fact that some of the members of the JSC said, let's postpone, doesn't mean that they were in contempt. They just were outnumbered. But there's no right or wrong. Yeah. All right. No, then it's clear, my Lord. So let's get that red herring of being bound, quote unquote, out of the way. So to give, and that's what we mean by material error of law. So for the JSC to think that they were bound in the literal sense, that they had no option but to refuse the postponement, or to give that as a reason, is itself a material error of law.
Does that interpretation arise from its letter?
From this letter, yes. So the preamble, not the 2.1, before 2.1, just the preamble.
Considers itself bound by the judgment.
Yes. So that's where that once you made that big material error, everything goes south, because you are thinking that you are bound in the literal sense. Now, my Lord, the funny thing is this. You remember that in the JSC's answer, they say we, What we're missing is that they had a discretion. And they exercised the discretion. And I agree with them, by the way. They exercised that discretion just as, it's funny how these arguments turn around. When we said in the Western Cape judgment, of course the National Assembly had a discretion to whether to designate or not designate. That's why they put it to the vote. That's exactly what the JSC did correctly. They would, if they thought they didn't have a discretion, they wouldn't have put it to the vote. They would have just said, we don't know what these people are smoking. And we obviously can't do this, and so on. But the mere fact that they put it to the vote means that they had a discretion.
Mm.
But in the same breath, they're telling you they didn't have a discretion because they were bound by the Western Cape High Court decision. So it's just a mishmash of irrationality. Now,
well, I mean, you've got to interpret the letter as a whole, haven't you?
my lord?
You've got to interpret the letter as a whole.
Yes, of course, of course. No, but I'm just dealing, yes, no, fair enough, my lord.
Yeah.
But I'm dealing it the way Mr. Manager dealt with it, that effectively there are three reasons.
Yeah,
The
yeah.
first one is that they are bound.
Yeah.
The second one is the one that I'm going into now. So then, my lord, here's this one takes the cake. So they say, well, MK in their letter, in their own letter, say that they are not sure whether it's 18.1 or 18.2 and so on, and it may or may not be binding. What have you? You heard all the submissions. But they forget one thing. You know, people sometimes make elementary mistake. All they need to do, not to make that absurd suggestion, is to look at the date. That's all. That's all. The date of that...
Does it really matter what the MK thought and when it thought it? The question is objective.
Absolutely. Firstly, it doesn't, exactly, my lord. Even if MK said, we are bound, it would be, the law is the law. That's the first point, my lord.
Yeah.
But the second point, which is even more important, is that at that point, the application for leave to appeal had not yet been served.
Yeah.
So, but all my learned friends argue this matter as if those applications had already been served. So at that point, theoretically, the matter, and I'm saying this very theoretically because it could not have happened. Theoretically, MK could have even said, no, we've decided no longer to appeal or whatever. I'm just using it theoretically. But as it happened, once they then lodged their application for leave to appeal, what page is the application for leave to appeal? Then Section 18.1 triggered itself on our version, or 18.2 on their version. That your lordship will decide that. But nobody must come here and say that in your own letter you don't say, because that letter precedes the filing of the...
Yeah.
Okay, so at least let's get that out of the way as well. If your lordship goes to 02132,
Yeah.
you'll see two things, Mala. 02,
That the application for leave to appeal.
sorry, okay, mine seems to be in a different place. 02? Yep. Okay, I've got it on a different place, my lord. But, and I don't want to waste it.
At 02-132,
132.
I have an application for leave to appeal. Is that what you want to take me to?
Okay, then my numbering is wrong. Okay, so I'll just use the natural numbers.
Give me the document and the paragraph number.
Yes, okay, my lord. It's an annexure to our notice of motion, I think. Yeah. Yeah, I don't. Oh yes. Okay, it's in the wrong place, so I'll just refer to it to. So on at paragraph. Let's start with the face of that. On mine is on 0285 for some reason. So it says notice of urgent application for leave to appeal.
Oh, right, yes, no,
Yes,
that's what I have.
that's the one, yes. And then it says the usual take notice and so on and so on.
Mhm.
And then further it says, and this is now, you remember the subsequent, take notice further that the said decision, which has final effect on MK and or Dr. Hlophe, will be appealed on the grounds set below. And that's the issue. So again, that might be right or wrong legally, that's not the point. But the appeal is brought on the basis that that decision has final effect on MK and or Dr. Hlophe. In other words, it's a Section 18(1) situation. That's, I just wanted to point that out. So there is no world in which the MK was now, having said its final and effect, bring an 18(2) application.
No.
Yes, because it was effectively saying we're bringing this. In fact, those words, it might as well have said we're bringing this under Section 18(1). That's what it means. Yeah. So that's the other red herring out of the way. Then, my lord, I agree with one of my learned friends, I think it's Mr. Bishop, that there is usually a confusion, and this debate is very complicated. It looks easy about 18(2) and interlocutory and final effect, Zweni, and so on. But there's always a confusion between the issue of appealability, which is one thing, and the application of 18(2). Those two things are not the same, contrary to popular belief. And I'll illustrate why they're not the same. Appealability is implied in 18(2).
Yeah.
And because we didn't need 18(2) if as Mr. Bishop says, all interlocutory orders were not appealable.
It's not even about that. It's about what happens when a party applies for leave to appeal against any order.
Absolutely.
Whether it's appealable
Absolutely.
or not.
Is another
whether
question.
it's final
Absolutely.
or not.
Exactly.
And the question is, what immediate factual effect
Must happen.
does the application for leave to appeal have?
Absolutely.
If the order is an interlocutory order not having final effect, it's not suspended.
Yes.
If it's an interlocutory order having final effect,
It's suspended.
it's suspended.
Simple.
If it's a final order that doesn't pretend to be
There's
interlocutory,
no debate.
Yeah.
Yes.
So
Thank you.
I don't think that we need to sort of delve too deeply into the theoretical debates
Yes.
about appealability and finality.
Yes.
It's fairly
but,
clear to
but,
me.
but it's important
Yeah.
only in this respect, madam.
Yeah.
If we are correct that one of can't remember which of my learned friends say interim orders are always non-appealable. That's not true. Even interlocutory orders, that the point I'm making, that even pure interlocutory orders, if they were always not appealable, then why would we have something called 18(2)? Because that postulates an appeal.
I think that was Mr. Bishop. He said, you know,
All-
in almost all cases,
Yes,
interim
yeah.
interdicts,
Always. He used the word always. Yeah. Okay.
are not appealable, but you know that where they have final effect, they are.
Absolutely.
Which
Thank you,
is
my lord. I'll move
the
on.
law.
Yes, I'll move on. My lord. Then, my learned friend, Mr. Maneche, gives me what we call a backhanded compliment, because in the Moyo case, we succeeded to distinguish between 18(1) and 18(2).
Yeah.
And for a change, the other side's argument was described as farcical. But that's a non-example, because in Moyo, it was exactly this debate, and we went into CIPLA and all those cases about appealability. So the issue in Moyo was appealability, not what we're debating here today.
Yeah.
And as it happened, that victory that Mr. Maneche was attributing to me was on the question of appealability short-lived, because as everyone knows, within a few months of that, the appeal happened, and it was actually reversed. And we even tried to go to the SCA on the basis that we should not have lost that appeal because it's not appealable, and the SCA said no. So that just shows that this thing is a slippery issue. Right. Then, my lord, there's another, this popular paragraph 56 that everyone is misreading. Paragraph 56 of the judgment says the respondent's submission that the JSC would not have a quorum in order to take valid decision if Dr. President declared from participating in that forum is incorrect. And then it goes on. Later I'll just read the part that Mr. Mann just said I didn't read, and to show that it actually assists us. One of my learned friends said that is I think it was Mr. Bishop. I think Mr. Bishop is was being creative, to put it mildly. Yeah. He said that this was a linguistic error. Yeah. But you see, you can't have it both ways. You can't say the judgment of the Western Cape, we must take it at face value when it suits you. But when it doesn't suit you, you point to a so-called linguistic error. There's no linguistic error, or if there is, it will be resolved in the appeal.
Yeah.
But for the purposes of your lordship, that paragraph deals with quorum. It does not deal with composition. It doesn't deal with Mr. Bishop, so that I can buy his favor now. Also correctly listed.
Is it for sale, Mr. Bishop?
Yeah, it is for sale. You only have one leg to stand on. And Mr. Bishop gave a list. He even increased my list. He said there's the issue of composition, which is true.
Yeah.
There's the issue of quorum. And then he included, there's another issue of attendance.
Yeah.
And Mr. Bishop is obviously correct. And that's why he had to find the linguistic error trick.
Yeah.
Because those three things are completely separate. The point of the matter is that even assuming, which we have to, that paragraph 56 is correct, it only deals with quorum. It doesn't deal with absence. It doesn't deal with composition.
Yeah.
And it certainly doesn't deal with what is called in the Bar Council case, the delicate balance that is sought to be struck by the Constitution in constructing, in designing, I think is the word they used, the JSC. Move on. Then, all my learned friends, no, this is Mr. Bishop again, yeah. Okay, I'm also going to be in his bad books again. Yeah. He says that the DA says about the other 5 people, no, we like them. That includes Mr. Malema. So we'll take that with a bit of pinch of salt. Yeah. But in that formulation, my lord, what the DA is doing on a more serious note is mixing up the issue of the remedy and the declarator. Because of course, my lord, I cannot stand here and say to your lordship, when it comes to remedy, your lordship must not take into account all these things. Is the sky going to fall and all that? I can't. Because when it comes to remedy, your lordship must do that. But when it comes to the declarator, your lordship does not have that option, because the constitutional writers took it away from your lordship by using the word must. So all the Mr. Ngatobi considerations and so on, of course, they'll be relevant in the discretionary part of the thing, but they're not relevant for the declarator. And this might even be an argument against myself, but I have to make it in fairness. I accept, my lord, implicitly, that, I think it was Mr. Bishop, that the likelihood is that the sky is not going to fall. Because courts, either way, by the way, there's no sky that's going to fall. Your lordship simply has to weigh the balance of convenience. And I'll make 2 illustrations. One, it is that there's been a vacancy, I think, in the Constitutional Court for 4 years, and the sky has not fallen. So if the vacancies are not filled in 2 or 3 months or whatever, the sky is not going to fall. But against me is the same argument. The sky is not necessarily going to fall if there are, let's call them invalid appointments. Because your Lordship and everyone here knows that in the so-called NTPP cases, the courts under Section 172(1) always fashion a remedy, which says, I think the Simelane case on Ngasana and so on, it always says, okay, this appointment was invalid. But for good governance, you can't say this NTPP is invalid, therefore all the criminals who have been prosecuted in the last 6 months can walk free. Nobody does that here. So the court will always accommodate those sky-falling things and deal with them in terms of 172(1)(b). Then, my Lord, so I'm just trying to go to the, oh yes. I don't intend to give a lecture on this, but I have to say this. If the law is very simple, if we are right that there's a prima facie or threatened right, Section 19 or whatever, then all your Lordship has to do is to do what is known as a limitation analysis. So your Lordship will have to say, okay, your right to participate in the forthcoming interviews translates into your right to participate in the political activities of your choice, Section 19. So prima facie, it will be limited. And that's all that is needed, my Lord. Limited. That word was chosen deliberately in Section 36. All we need to show, my Lord, is that that right will be limited. And it says in this book of Carré and Duval, I don't know if it's the latest edition. Limitation, page 151. Limitation is a synonym for infringement or perhaps justifiable infringement. And here's the important part. It says a law. So even the court order, let's call that a law. A law that limits a right infringes the right. Let me read that again. A law that limits the right infringes the right. So a court order that limits the right infringes the right. So you can't have a circuitous argument that says, no, it's justified because it's a court order or a statute or a whatever. Because if it limits the right, it limits the right. And then it says, however, the infringement will not be unconstitutional if it takes place for a reason that is accepted as a justification for infringing rights in an open democratic society based on human dignity, equality, and so on. And where an infringement can be justified in accordance with the criteria in Section 36, it will be constitutionally valid. Then I'm jumping to the bottom. If rights can be overridden simply on the basis that the general welfare, which is what we're told here, will be served by the restriction, then there's little purpose in the constitutional entrenchment of rights. Yeah. So all these big stories were told, oh no, the judges, or the burden of the courts are going to all crumble. The general welfare, they say, if you were to take those into account, then what's the point of having entrenched rights? And then said, but however important the purpose of the limitation, restrictions on rights will not be justifiable unless there's a good reason for thinking that the restriction would achieve the purpose it is designed to achieve, and that there is no other realistically available way in which the purpose can be achieved without restricting rights. In other words, to bring it home, we'll have to show that there's no other realistic way, such as the postponement that you are proposing, in which you could avoid the limitation of rights. And our case is that there is. Now, here's another one, Melon. We are now being beaten up for being realistic. So my learned friends say, well, you should have then just come to say, no, we want Dr. Hoppe to be there on Monday. Of course, we could have done that. But how can we be punished for doing that which is responsible citizenship? where we're saying, we may be right, Dr. Hlophe might be entitled to go there on Monday. But no, we don't want to take that option. We're saying, let's all hang 10 until there's clarity. And now Marlene Franz says, you know, what you should have demanded that we're going on Monday, or walk in, or do a sit-in, or I don't know, whatever. But the only thing we're asking is for rationality. And we're saying, given the shortness of time, the fact that we cannot do, even if we were to do a Section 18, neither us nor you can do a Section 18 in 4 days. Parliament is in recess. The meeting is next Monday. It's not a creation of our own that the judgment was only given on Friday. We are all been put in this situation. Given all that, let us take a via media of pausing and making sure that nobody's rights are infringed or limited. And then they say, no, you should have gone for the jugular and cut our necks. We don't want to. You can't force us to do something, because we are mindful of these issues, my lord. It might well be, what if Dr. Hlophe goes there on Monday, possibly or otherwise, and then a week later there's Part B, which says he should not have been there, as we've said. Then you have the flip side of the problem. So all we're saying is, no one must be put in that situation. If Dr. Hlophe is right, don't prejudice him by permanently removing him. And by the way, this thing of final effect must be addressed. It might look on a piece of paper as an interim or permanent or temporary setback. But the reality is that, and that's what we mean when we say it has final effect on MK and Dr. Hlophe. If the meeting continues without Dr. Hlophe, it is irrecoverable and irreversible that he would have been deprived of participating in those interviews. So it's final in effect in that sense. Similarly, MK's, I was about to say bragging points, but it's more serious than that. MK's right to have its member sitting in these interviews would have been permanently and irreversibly, till thy kingdom come, have been...
That's right to have that particular member.
Absolutely.
Yeah.
Yes. So that's what we mean by final in effect. And we're talking about human rights here. We're not talking about some frivolous thing. So if you deny or limit, I prefer that word for obvious purposes.
Yeah.
If you limit that right even to that extent, that has a permanent and everlasting effect. Then, my lord, on a lighter note, we were told that Mr. Trenkov made a transient submission, and Marlene Franz corrected himself that when he said it was cogent, it was obviously not cogent because he lost the point. Yeah. And that point was this: Mr. Trenkov's client FUL and Mr. du Plessis, for that matter, was saying that they should be given final relief alongside the interim relief, and the court, in a balancing act, found against them and said, no, we'd rather postpone that to Part B. So that's that's what happened. So that and then, my lord, we're also told that, but against Mr. Ngalwana, it is said that you have not challenged the other 5. But we've said this in our, I know your Lordship hasn't read our reply, but when your Lordship does, we'll make the following point. And I can say this from the bar, I hope, unless my learned friends object. We do hold instructions, my lord, to challenge the other 5, if you like. And the only way we can do it, and because one of my learned friends, I think Mr. du Plessis, correctly analyzed the situation in his affidavit. What we'll do, my lord, is what is called a conditional counter-application. Because obviously, and one of my learned friends was correct to say that you can't blow hot and cold. So what we're going to say is to say, if we are wrong on the Ngalwana argument, then conditionally, then the other 5 are also tainted. But here's the point. You can't do that now. You can only do that when we answer to Part B. Because we'll do the conditional counter application as part of that. We're still far from that. They have not even done the supplementary affidavit in terms of Rule 53 and all that jazz. So when all that happens, we will then do the Rule 53. And as I say, even from the bar, we will then attack that that issue. So you can't criticize us now. How are we going to do it? Let's say we wanted to attack it. We can't. It's too early. If you want to criticize us, just wait until you get our answering affidavit. Then, my Lord, I'm coming towards the end.
Yes.
Your Lordship really hit the nail on the head. Now, before we do that, let's go to Mr. Bishop. Mr. Bishop cites the case. There's some the case of the public protector. It's some case here in which I was gratuitously insulted. Now, that case, my Lord, is not authority for the proposition that Mr. Bishop says it is. That case, what happened in that case is that in the, actually that case works against him. In the High Court, in the full court in the Western Cape, the public protector said, there's been bias and all sorts of things. Somebody's husband was judging me and all that. and it should be reviewed on that basis. The court, in our respectful submission, wrongly, and I say that boldly because that process, that case is still in the appeal pipeline, so to speak. So it may be confirmed or not confirmed. And that's another reason why Mr. Bishop may not rely on it. I can put every cent I have that that case is going to be appealed, if nothing else, because the client is aggrieved. Me, I'm fine. So what that court said, it said it's in medias res, because the Section 194 thing is still running. But the court did something which, and I don't want to criticize the court gratuitously and do the opposite. The court did something that should not be done, which, imagine if your Lordship said this, I'm not going to give you the declarator, and that's it. And therefore, I'm not going to look at prayer 3. That's what that court did. So it was blatantly wrong, because it said, it's in medias res, and therefore we're not going, and Paja doesn't apply. Therefore, we're not going to look at legality, which is bizarre. But that court was not authority for the proposition that a decision, which Mr. Maneche, to his credit, has never said that it's not a decision, because it is. A decision is somehow in medias res, or is not an administrative decision. Which, by the way, in case I forget at the end, deals also with the question of cost. I mean, this is the biggest irony. Mr. Maneche, who's my real opponent, says he's not looking for cost orders. And then some people who just came for a reason that we cannot understand. Yes, but on the basis that only if you oppose, I'm sorry, my Lord, I shouldn't be responding to the banter. Yes. but let me say this, my Lord. The reason why, paragraph whatever it is of our founding affidavit says exactly that from number 2 to number 22, they are only cited of any interest they might have, but no relief is sought against them. That's the point. So the only relief that was sought was against Mr. Maneche. I know they were cited because I'm the one who cited them. But the point is that what is the DA and FUL? Why? What is their business about whether there should be a postponement or not a 'They said in Cape Town they were protecting the rule of law, fine. And
I think their view is the rule of law is best protected by the JSC proceeding without Dr. Klorpe.
aha.
Might be right, might be wrong, but that's why they're here.
Exactly. But that's exactly, remember the shoe is now on the other foot.
Yeah.
We are also here now to say exactly that, my lord. We're here to say the rule of law, rationality, will be best served by reading the letter of reasons of the JSC and on its assessment make declaring it to be irrational. That's exactly. So the only reason we're here is of course to protect the rights of the principal parties. But the broader reason, which is why 172(1)A applies, is because we're here to protect that rule of law. So they can't say when it was their turn, rule of law, and then now when the Dr. Klorpe and MK say, well, the rule of law says that we should postpone, then they say no, go forge ahead, break the rule of law. Now, yes, I have to say this about Mr. Du Plessis so that Mr. Bishop doesn't think I'm only picking on him. Mr. Du Plessis' client misses the point, really, by a mile. Because their case is untenable. Their case, they say, the court has a discretion on the declarator. The court doesn't have a discretion on the declarator. They make that mistake because they miss the law. And you can see why they miss the law. They rely on Ogbay, on that case of Ogbay, the Gupta's case. That case, my lord, was not brought under section 172(1)A or even section 38. It was brought under section 19C of the Superior Courts Act. In terms of section 19C of the 191C of the Superior Courts Act, of course, the court has a discretion to grant in what we call an ordinary declarator. But that's not what we're talking about here. In this case, we're talking about section 172(1)A of the Constitution. So Ogbay has got nothing to do with what we're discussing here. And then yes, Your Lordship, to one of my learned friends said, and this is hopefully the last point, when I was saying Your Lordship hit the nail on the head, Your Lordship summarized it as follows, and I'm going to borrow the words from Hoekstra and Penfold. The relief that we seek has got two pathways. Can't remember the word Your Lordship used, but it's something to that effect. And these pathways must not be confused. Mr. Manecha, I'm picking on him now, makes the fundamental mistake of not appreciating the gravamen of the Hoërskool van Warmelo case. Mr. Manecha says wrongly. It doesn't matter whether you are looking for the common law right or whether you are looking for the constitutional interdict. It's all the same test. You have to apply the same test. No. And the authority for that, my lord, is a case called EFF versus Godin. EFF versus Godin makes it clear, my lord, that there are three things. There's what we call the normal outer test. There's the section 172(1)B van Hoërskool Ermelo type. And then there's a third category, my lord, called suspension. So if you are if Your Lordship in your wide discretion can say, I'm not doing any of the things that Mr. Mpofu is asking me to do. So I'm not going to give you a common law interdict, and the pun is not intended, interdicting the interviews. I'm not going to give you a common law interdict, And I'm also not even going to give you a whole school MLO relief. But I'm going to give you relief that says that the interviews are suspended, or suspend the decision, the non-postponement decision. And I'll show you, my lord, what impact that all has on the tests. If you go to EFF versus
It's the Constitutional Court decision.
yes, the Constitutional Court, unanimous. There were two decisions. One was Khampepe, which was
Everybody
unanimous.
concurred.
Yes.
Each judge concurred in
But
both.
both of the, yes,
Yeah.
both unanimous, yes.
Yeah.
So if you go start at 108, my lord, it says when the High Court determined the first part of the application, it was exercising powers conferred on it by Section 172(1) of the Constitution. On the authority of Howard School Ermelo, the power to make a just and equitable order does not depend on first declaring law or conduct invalid. Considerations of justice and equity permeate every order made in a constitutional matter. I say a lot more about this later. In other words, to paraphrase, the only test on a 172(1) basis is considerations of justice and equity. Is it just and equitable? And then he says at 109 chapter J, therefore the High Court erred and concluded that, which is what this court is being asked to do, that Part A of the application before this court does not constitute constitutional litigation. Okay, that's a different point. The fact that the interim interdict may be granted in non-constitutional litigation does not mean that if sought in constitutional litigation like review, it is not part of that litigation. Here's the important part. Earlier, and relying on the decision of this court in Outer, that's Mr. Mainecha's point, the High Court held that the purpose of the interdict was to protect rights yet to be determined. Then jump, my lord, to 110. The outer standard which the High Court embraced and applied is applicable to constitutional matters, and so on, what we all know. Then at 113, I think is the gist. Yeah. Says, therefore, even if it could be said that there were prospects of success against the grant of the interdict, the applicants for leave would still be faced with the question of whether there was prospects against suspension. In other words, whether the suspension of that, or I think it was remedial action of the public protector or whatever in that matter. And here he says, requirements for suspension differ from those needed for an interim interdict. The outer standard does not apply to suspension. So even though we all know that a so-called suspension in effect is a prohibition, so it's an interdict by another name. Even though it would have the same effect, but to that relief, the outer test does not apply. And that is for a reason. So Mr. Mainecha's thesis that it matters not whether you are in the land of 172(1)B or operational structural interdict or whatever, it all comes back to outer, is wrong in law, according to the Constitutional Court. So your Lordship's mapping of the two pathways is therefore correct, which is to say simple. One pathway is declarator, 172(1)B or Section 38, gone. But if we are wrong on that, then the second pathway is, in fact, there are three pathways. The second pathway is Mr. Ngalona's approach. Common law, normal, outer, and all that, boom, gone. But the third pathway is your Lordship fashioning a relief such as a suspension, where your Lordship will not be then bound by the outer test and all that, but by the interests of justice and justice and equitability and weighing these. Where Mr. Mainecha might be right is that even in that exercise, obviously one has to look broadly because it is by its nature discretionary. But that's not the same thing as saying the outer test, you just plaster it around like that.
Yeah.
Thank you, my lord. I'm just checking if there's anything else, my lord.
Yes.
Okay, yes. My lord, I won't belabor this point. I implore your Lordship to just do a simple exercise and take our letter to the JSC on Monday and then take the letter that the JSC wrote to us on Tuesday. And I must commend the JSC for they actioned our letter. Within that evening, I'm told there was already a virtual meeting or whatever. And the Lordship must simply say this. You'll see in our letter, we even apologize. We say we apologize for the length of this letter because we wanted to avoid this kind of debate. That's why we went to town to say the Section 18 might happen, might not happen. Please, this is not about the quorum, it's about composition, and so on and so on. Because we didn't want, when people are sitting in that meeting, to be debating those trivialities. And wrote a very detailed letter. So if your Lordship takes that letter and see the spirit in which it was written, which is to say, let's avoid litigation, let's have a draw kind of situation where there's a truce. And then you see the response to that letter, which actually makes it clear that they did not read the letter, or if they read it, they didn't read it properly. Because then they come and do exactly what we said they mustn't do. They conflate quorum with composition, and then they invoke Section 18 in vain, which is what we had gone to town to make sure that they don't do. And we even sent, once the leave to appeal was out, we immediately sent it in the evening, I think an hour before their meeting. All this was for one purpose, so that they don't get waylaid into the wrong Section 18 wild goose chase, or the wrong Section 178 wild goose chase. But that's exactly what the JSC did, with the greatest respect, and ignored the via media that we were trying to say, and went gung-ho, no, we're bound, and no, it's 18.2, and no, he was not removed. And my Lord, this is the last submission on the SCA. Surely, Mr. Bishop cannot be serious that this court is bound by the full court interpretation of the SCA judgment. Because there's one of two things. Stare decisis doesn't work like that. If as Mr. Bishop, and I hope I'm not targeting the wrong person, if as my learned friend says, that all that the Lidwaba DJP and Sutherland DJP judgment did was to confirm the SCA judgments. That's scenario one. Then, of course, your Lordship is still bound by the SCA judgments more, because they have a binding effect. Obviously, two SCA judgments versus a full court judgment, the binding effect will lie with the two SCA judgments. If, on the other hand, that's scenario two, the High Court judgment contradicted the SCA judgments, then again, your Lordship is still bound by the SCA judgments until they are overturned, until there's another judgment that says the full court was right. So, whichever way you look at it, the judgments that are binding upon your Lordship are the two SCA judgments, and both of them say the same thing. They say the following: the general rule, and to his credit, Mr. Maneche accepted this. The general rule is that if the JSC is not sitting en banc, then it's invalid. That's the bottom line. However, it says, those courts say, and that's the thing about the justified exclusion. Yeah. Of course, as all legal rules have, they always have an exception. Of course, if there's a justified reason, then that general rule may be attenuated. We all accept that. But let's not confuse the court. The general rule is very, very simple. It comes from Ski Road. If there is a statutory board of directors, school board or whatever it is, which is prescribed to sit as a whole, then if it's not sitting as a whole, that decision is invalid. So the question before your Lordship is a narrow one, going to your Lordship's straight line example. It's very simple. Is there a valid justification for the non-postponement decision of the JSC? There either is or there isn't. If, and nothing has been said to convince anyone in this court, least of all your lordship, that there is. And to do that, your lordship will have to go back to the exercise I asked your lordship to do. Take the two letters, and your lordship will see that none of those things listed there lends itself as a valid justification for the non-postponement decision. Least of all, the idea that because you are bound by a decision, therefore it means you must not postpone. And if we're correct in that alone, then your lordship must grant the declarator, and the rest I'll be repeating myself. So those are our submissions, my lord.
Yes.
As far as costs are concerned, our respectful submission, there was some contrivance about the fact that these people are working in Parliament and therefore they are public. I don't think that was seriously meant. So apart from the issue of the freedom of expression or no freedom of expression, which your lordship is correct, and let me speak for myself. I agree with your lordship. One cannot condone those remarks. But whether or whoever issued that statement or did not issue it or was part of it or knew about it and so on, that might be clarified in the appropriate inquiry, as your lordship said, not before your lordship. So apart from that, my lord, if there ever was a deserving case, it is this one, my lord. To actually say somebody whose fundamental rights in terms of Section 19 are being limited, infringed, violated, whichever word you like, must be punished for coming to court to say, court, please rescue me. I'm being closed off in sentence somewhere, and that act infringes MK's rights, and it also infringes Dr. Klope's rights. Rightly or wrongly, win or lose, to say that to actually assert that is a punishable offense, my lord, is really gilding the lily and taking things too far. So, my lord, with the greatest respect, your lordship must, with the greatest respect, I say this with the greatest respect, find that the legal effect of the Cape Town order is to reduce the constitutionally ordained 50% threshold to 40%. And by doing that, ipso facto, what was said in paragraph 35 of Bar Council, the constitutional design is disturbed, and so on. And a court order cannot be allowed to do that because it is the Constitution that is supreme, not the court. We respect the court. The court can give orders and so on, but no court can give an order that breaches the Constitution. If it does, obviously it's not doing it advertently. And if it does, then the court, this court now, it is the duty of this court to say that the legal effect of this, intended or not intended and so on, but the legal effect of this is to disturb the constitutional design. And I, as the court, will not allow it. And then I'll find some structural way which balances all the rights, what all my learned friends have said. And that's all we're asking your lordship to do, so that on Monday we don't have an illegality continuing in our town. Thank you.
May I ask for your leave just for half a minute?
No
just
objection.
to deal with an issue that we could not have anticipated, which is the instructions
Yes,
conveyed
half a
from the
minute.
bar that there will be a challenge to the 5. The implications of that is that the promises of our learned friends that this, if there's going to be a postponement, is a 2 months or 3 months postponement, is really pie in the sky given all these challenges that are coming.
Yeah.
That's all we needed to draw
Yes,
that to
thank
your
you.
lordship's attention. As the court pleases.
Sorry, my lord. I don't object, but I just have to say one sentence. That's not true. All my learned friends have missed everything. The reason we say, my lord, we give you 3 options for the, let's call it part B. My learned friends have all missed this. We say either you must await the application for leave to appeal, and we concede that it's not going to take 2 weeks. Might take 2 months, might take 3. Mr. Manager might be right, it might take 100 years. Okay? And then we say the second one is that Part B of the Western Cape Court must be entertained. Take 1,000 years, it might. But we say, or Part BB, whichever happens first. And we've demonstrated to your Lordship that Part BB, which is really the analysis of a letter, can never take more than. That's all we're saying. So we accept Mr. Manager's 20,000 years for the thing. But the way we formulated it was to make exactly sure that we ameliorate any harm that might eventuate by taking the lowest threshold, which is Part BB. Assume the courts won't give us expedited hearing. Assume we'll bring 1,000 counter applications, whatever you. But surely your Lordship knows that any JP will be able to case manage this thing such that it can be disposed of quickly. We're not making, so I'm not putting, I don't want one day to say you said 3 months or whatever. I'm simply saying this is not this whole thing that the sky is going to fall is 100 years and so on. It's something that can be limited, but in the best case scenario for them, it can only be pegged to Part BB, which, by the way, your Lordship said might even be rendered academic.
Yes.
And I agree with them.
Thank you.
As God pleases.
Yes. I propose to reserve judgment for a short while. I anticipate being able to give judgment during the course of tomorrow. I will circulate the judgment by email. My registrar has a list of all interested parties. I dare say that if members of the press present wish to receive the judgment more or less as it's handed down, if they send my registrar an email, he will accommodate you on his list. Mr. Mpofu, Mr. Mayaniche, that is sufficient to allow your clients to organize themselves in light of whatever I decide, is it?
Yes.
A judgment during the course of tomorrow.
Yes, I think it should, under the circumstances that.
Yes. So if, in other words, I say the JSC meeting can go ahead, I won't make that impossible by taking until tomorrow afternoon to say so.
Yes.
That's
because of travel arrangements.
Yes.
And all that.
Yes. So if I decide the JSC can go ahead, to do so by tomorrow afternoon wouldn't create any problems.
I would assume, but I think my client would appreciate that that's most expedited.
Yes. Yes.
Response from the
Yes.
judiciary.
I'm not going to give an order with reasons to follow.
Yes.
I'm not going to extemporize.
Yes.
And the fastest I can move in a case like this is just under 24 hours.
We would accept that.
Yes.
My Lord, similarly, my Lord, we accept that. In fact, just to give your Lordship the assurance, one of our options was to set the special time for Saturday, but we wanted to avoid exactly that.
Yes.
So the reason why it was done on Friday was so that anybody can make whatever arrangements my clients might want to make on either eventuality.
Yes.
We are in the same boat. We don't expect your Lordship to do miracles.
And presumably no difficulty from full or the DA's perspective.
None, my Lord. None, my Lord.
Very well. Judgment is reserved for a short time. Thank you all for your assistance. Thank you all for more or less keeping to time.